It's 12:15, so we'll get started. I'd like to welcome everybody to this seminar in the Peking University School of Transnational Law and Humanities seminar series. For those of you who may not be familiar with our law school, we also call ourselves STL, S School, T Transnational, L Law, the School of Transnational Law at Peking University. My name is Norman Ho. I teach here at the law school. We're very privileged and honored to have today as our guest speaker, Dr. Michael Ying, who serves as professor and also associate dean for research at HKU Hong Kong University's Faculty of Law. Professor Ying's research interests are in legal history, especially the legal history of Hong Kong and also of modern China. He's published widely in these areas, including both monographs and articles. His monographs include a book called Political Censorship in British Hong Kong, which came out in Cambridge University Press. He's also the author of a book entitled Legal Transplantation in Early 20th Century China, which came out with Routledge. That book is actually the book, to tell a personal story, which introduced Professor Ying's work to me. It's a great book. I recommend it to everyone about lawyers and the practice of law in early Republican China in the early 20th century. And Dr. Ying is also quite rare among legal historians for another reason, is because he also teaches commercial law at HKU. He has over 15 years of experience before becoming an academic in the legal and finance fields in Hong Kong. And he also previously served as a CEO of a private equity fund in Hong Kong, so is also familiar with the financial and legal aspects there. Today, he'll be speaking to us on the topic of the common law in Hong Kong legal history. Professor Ying will speak for about 35 to 40 minutes, after which we will open the floor for questions. I would like to now give the floor to Professor Ying. Thank you.
Thank you very much, Norman, for having me. Thank you, SEL, for having me. This is my first time here. I'm very honored and privileged, and fascinating team, fascinating campus. I'd like to be here more. So thanks for the very kind introduction. Okay, thank you very much. So if I want to turn to the next page, so I will. Great. Okay, great. Thank you so much. So happy to talk about a quick recap of my past project, as well as an update of my new project, which is interconnected about the common law in Hong Kong legal history. To a lot of people knowing Hong Kong or hearing about the legal order or legal system in colonial Hong Kong, seems to be there's not much things to be talked about because it's all settled in textbooks and other works. But for those who knows my previous scholarship, I'm in addition to my legal history of modern China, in recent years I've been very correcting, but in a way revising the legal history of colonial Hong Kong, in a way to hopefully demythologize certain myths that has been contained, celebrated. Yeah, sorry, no worries, no worries. So demythologizing certain narratives and highly used texts in mainstream textbooks or orthodox scholarships. So one of the things that I'm trying to do is to look at whether the common law, obviously we know we practice common law as in other former British colonies as well as the UK, but was the common law system practiced in colonial Hong Kong period a system featuring common law, rule of law values, or the lack thereof? I know it's very elusive in terms of what is rule of law, what is common law values, but I think there's a common denominator that we can extract it to illustrate this point. Say, for example, in highly used, highly popular textbooks in both law and history fields. When they're talking about colonial legacy in Hong Kong or legal colonial or colonial legal legacy of Hong Kong, they would very much celebrate two values, which is a shared common law values that Hong Kong inherited from the English common law system. Number one, freedom of expression. Number two, judicial independence. I think these are one of the two least debatable rule of law and common law values that these textbooks said because Hong Kong practiced common law, Hong Kong practiced those common law values or rule of law values. So therefore, the rule of law and common law that we are practicing today was a colonial legacy or was an inheritance or a very nice inheritance of those values because Hong Kong practiced common law system. For those who have heard my previous book talks before, I'm sorry that I have to repeat that, but I'm trying to build on my previous works on debunking the myth about the existence of freedom of expressions as a common law values in the 150 years of common law history in Hong Kong. And then I'll move on to the next value, which is judicial independence. So my English books published in 2022, followed by the Chinese editions last year, talks about the lack of freedom of expressions in the common law system practice in Hong Kong by showing the very widespread and pervasive political censorship over the press media, electronic media, as well as in schools. So I'm going to do a quick recap on the past projects so that you know where my existing or future projects is heading towards. Actually, I'm not here to be honest, I'm not here to share too much new insights, but I'm here to seek your insights, as you will know at the end of my presentation on my new project. So as a very quick recap, so this is 1850s newspaper clippings. As you know, I'm a legal historian, so most of my research is not, if not more, if not all, was based on archival or declassified material sourced from National Archives in the UK, Singapore, Public Records Office in Hong Kong, and some other places. So it's purely archival based. So this is the archival news reports showing in 1850s, this gentleman, Mr. Merrill, was prosecuted by seditious libel for publishing a report saying or reviewing one of the contract tendered, obtained by a trading firm. The partner of the trading firm was a son of the colonial governor. Of course, this was a very naughty report and had to be punished. So he was punished, he was fined and imprisoned. So not only when the colonial government is forced in London was criticized, they would be suppressed, fined, and imprisoned. So even criticisms against British Empire's allies will be punished. These four newspapers in the 1880s during the Sino-French War, when they published report condemning the French people in French army, they were prosecuted. Okay, so that means for, if you think about common law values again, or the lack thereof, so you'll see, or you would be surprised that not only criticisms or expressions against local government, London government, but even the broadly defined European allies would be punished. Because for the purpose of, politically speaking, the local Hong Kong government would not like Hong Kong to be a base of anti-European sentiments. So this is a sedition law in Hong Kong. So it's not the present law. Although a lot of keywords share the same, actually it was originated in 1920s, originally not designed to manage expression of the local Chinese people. It was designed to manage ethnic minority people in Hong Kong, who was very important to British Empire. Who are they? Indians. Because most of the former British colonies in Asia was policed by Indian police. Shanghai included, Singapore included, Hong Kong included. And during the 1920s, so there was a movement called Garda movement, which means Indian independence. So therefore, to avoid those Indians police to rebel within the government system as a policeman, which is very, very dangerous. So therefore, Hong Kong, along with other British colonies in Asia, invented the now very famous sedition law. And many keywords back then were still used in many former British colonies, including Hong Kong, in their laws, such as hatred, contempt, disaffection, without much elaborations. Those were still continuing as a colonial legacy, but of course not the legacy of common law values as such. So this is just a illustrations of how these people were threatening the British Empire. Hence, freedom of expressions were not manifested in the common law system, or broadly, or quote unquote rule of law system practiced in colonial Hong Kong. So therefore, just examples of these people were really charged under sedition law in Hong Kong. It's not only a threat on the boat, it was practiced to suppress the press as well as freedom of expression. So, as I said, putting aside common law values, actually, the law was used to suppress free press, not only because of criticisms against local or London government or even European empires. It targeted also to manage the situation happening in China, or happening in mainland China, okay? Next door, basically. So this is, I would say, to a lot of people, very surprising laws that order the pre-vetting of newspaper manuscripts before printing for any Chinese newspapers. It was a law passed in the 20s when Hong Kong was undergoing major strikes, basically encouraged or instigated by the United Fronts of Chinese Communist parties as well as the Chinese nationalist parties, that facilitated the occurrence of major strikes in Hong Kong, one of which is called Seaman strikes, the other is called Canton Hong Kong strikes and boycott, 香港大罢工. So within those days, the British Hong Kong government was very scared by those movements because that paralyzed the economy. That to them might lead to the overthrow of the entire colonial governance. Therefore, this regulation said no one shall publish anything in Chinese except first going through the Secretary for Chinese Affairs. Therefore, we had this very secretive government unit invented, which I'm sure before my book was published, no one knows it or no one said it, okay? It's called Newspaper Censorship Office, okay? 香港报纸检查处, okay? Which this is the archival documents that I found showing the opening hours of this office. So it had Chinese, ethnic Chinese government censors working for that under the, of course, British Secretary of Chinese Affairs. So the opening hours may look quite interesting because it only worked in the afternoon and in midnight. They were not lazy as such. Why? Because they would need to read newspaper manuscripts. As you know, journalists collect news stories in the morning, in the daytime, wrote their stories, put together layout, and then originally sent to print. But now, one step in between, they have to send the final manuscript to the government censors to read and to approve or not approve before they could be printed. So therefore, you will see a lot of sensitive words, phrases, paragraphs might be regarded by the colonial Hong Kong government as sensitive. They would be struck off. As I read from the archive, those censors use red and blue pencil or pen to strike off the forbidden words. And if you were the editors, when you receive the revised manuscripts, so in the days without Microsoft Office, how would you be able to change the layout 1 hour before printing during 1 a.m. in the midnight? So it's next to impossible, right? So they were very clever. They created placeholders. This is the image of newspapers sold in the street in a published form after being censored. And after sensitive words, replaced by placeholders like crosses, dots, square boxes. So it's very fun to choose, what they have censored, so that you know what should be or what are the sensitive words. So in these newspapers in the 30s, it's not too difficult to guess. It's about some bombing, it's about Chongqing. So the crosses should represent, I don't have the answers, I don't have the marking scheme, but I would say it is likely it represents Japan, Japanese army, so Japanese people. So we consider the red line within the common law values, so, okay, against the freedom of speech. You can't criticize local government, you can't criticize London, you can't criticize European allies, you can't promote Indian independence, you can't even criticize Japan. Why? Japan's eventually invaded Hong Kong as well. So, but if you put the legal history against international context, as I always tell my readers, my students and colleagues, Hong Kong legal history is not about a legal history of one small city. It's a very important episode of international geopolitics. It's a very important episode of international relations between China and the rest of the world. So if you put this against the context of Sino-Japanese foreign relations history, you would know that Britain tried to remain quote-unquote neutral with regard to Japanese invasions in Asia. So being neutral, the UK government, the local Hong Kong government would not like Hong Kong populated mostly by Chinese to make Hong Kong a base of anti-Japanese sentiment. So therefore, these things have to be deleted for state security from their point of view. Okay? But sometimes the questions could be harder to answer. When you see so many boxes, you would not be able to guess what has been deleted. But I think the interesting thing is, even though I could not guess what has been deleted, one thing I could tell from those pages, number one, you see all these advertisements, medical advertisements. This should not be the front page of the newspapers. So that means you can see that those censors did not just, briefly browse over the front page and then take off sensitive words and then let go. So it would really go into the details of the inside pages and see small articles, and then not only cross one or two keywords, but they would be as far as crossing out the entire paragraphs. So that is the extent of quote-unquote free speech under the common law system of Hong Kong. Sometimes, if you are the editor, you don't want your pages appearing with too many crosses and dots. So you might be clever enough to pre-submit some of the scripts for censor's opinion before even putting them together in the layout. Okay? So, but sometimes, just like, we're a teacher, we hate to do that with a big cross, but sometimes we had to, okay? So the government censors returned the manuscript with a big red cross, disallowing it to be published. I think the red cross is not the most important thing. You should look at the blue chops. The blue chops testifies that the existence and operations of this census office in reality. The blue ring, outer blue ring says, 香港報紙檢查處, 香港報紙檢查處, Hong Kong Newspaper Census Office. The inner ring says, 此稿不能刊载. This manuscript is not allowed to be published. So it's a firm evidence. Okay? So another interesting story is that it's like this is not because the people in Hong Kong, at least the elites or the publishers, did not cherish free speech, did not insist that free speech should be one of the values to be shared in at least common law system in Hong Kong. It's because the government did not allow. The evidence is that at one point of time in late 30s, one of the legislative councillors in Hong Kong called Lo Man Kam, Lu Wenjin. So he was the partner of one of the oldest Chinese law firm in Hong Kong, still existing, called Low and Low. So he was a Eurasian. He was trained in London. He was qualified as a barrister there and a solicitor as well. An open law firm in Hong Kong. He was appointed as the Chinese Legislative Council. He was asked by more than 50 press publishers and editors to submit a petition and start a motion in Legislative Council to request the government to abolish the pre-vetting system. Very interesting fact is, he tried to use Horseferry laws of England and Blackstone that he learned from the UK to try to argue within the common law that he was taught to persuade the government to give up the pre-vetting and suppression against free speech. Of course, the result is, because of the concerns, state security, and all other reasons by the colonial government, it was rejected. But the most interesting part is, not only the motion was rejected in the council, the newspaper reports that reported his reasons for submitting the motion was censored, like this. So all the dots, I guess, cover what Mr. Low mentioned about the reasons for the abolitions of the censorship system. So you can see how in broad daylight the pervasiveness and the openness of this press censorship system, and place it within the questions, what is the common law value manifested in Hong Kong's colonial legal system? So, so if you're not following the striking or deletions of the census, of course you will be brought into court. So those editors were punished for not following instructions sometime. So fast forwarding, PRC established that from the colonial government point of view, gave them a much larger pressure to increase the efficiency and efficacy of censorship systems. Because after the PRC was established, a lot more people coming to Hong Kong. So a lot more newspapers not allowed to be published in China. They came to Hong Kong to open office and to publish. And also after World War II, the colonial Hong Kong government might not have the resources to pre-vet every newspapers, every article, every night. So therefore, they thought of some more expedited way of solving the system. Instead of deleting the words and articles, they chose to delete people. They chose to eliminate people. When people was not there, problem would not be there. So therefore, they created 3 very important laws for that purpose. One is detention regulations, which means detention without trials. So people could be detained for indefinite period if the government thought it is of public interest. Okay. Number 2, deportations. So because most of the people in Hong Kong back then were not British subjects, because they were Chinese migrated from mainland China. So they would be subject to deportations. So overnight, they could be deported. So when people were eliminated, problem didn't exist anymore. So not even giving them a chance to write and publish with dot and crosses. So for the colonial government, this is the best way to control speech, even without the need to bring them to court. So as you can see, during the Cold War period back then, a lot of left-wing newspaper editors, principals and teachers of left-wing schools were the target of detention and deportation. Most of the time, they were deported back to mainland China. So these are the newspaper reports of the deportation. But remember, detention without trial was something that the common law values and rule of law principles firmly against. But there were exceptions in colonial eyes. So today, when you are in Hong Kong, welcome to go to this historical monuments containing the detention center for political dissents under the detention rules that I mentioned. They were detained here in the white blocks. This is a building very close to HKU in Victoria Road. So you would be able to see the best sunset in Hong Kong there. It's open to the public. So, but another place was now occupied by University of Chicago, Hong Kong Education Center. And also they were responsible for maintaining this. Very luckily, it was maintained, these historical relics of cells operated by special branch of Hong Kong police for detaining political dissents. There's another one which was demolished already. So another one in Kowloon Sai, ironically, it was very near to now the site of Hong Kong Hong Kong History Museum. Okay, so why one in Victoria Road? Why one in Tsim Sha Tsui East? The question is efficacy of elimination of people. Because here, if you jump on the boat, very quickly you'll be sent to Zhuhai or even Guangzhou. Okay, when you travel towards west after passing through Lantau Island. Why Tsim Sha Tsui East? Because originally the Star Ferry Pier was the locations of train terminus. So next blocks you can be detained, and then overnight you'll be sent to the train stations and then sent back to Lo Wu. So efficacy. So I mentioned 3 regulations. So the third one is called Control of Publications Ordinance, where the governor was empowered to shut down presses and confiscated newspaper manuscripts and arrest and detain journalists and editors if the governors or the attorney general suspected that seditious publications could be published. So during the 67 riots, as you can see from the newspaper, policemen armed with shotguns shut down 3 left-wing newspaper presses. But I have to stress that these kind of measures to control the press or free speech are not restricted to treat left-wing's political dissents. So this is Guomin Ribao, which is the Kuomintang Nationalist Party-run newspapers in Hong Kong. They were suspended as well if they crossed the political red line, so to speak. So in the 60s, 90s, 60s, 70s, so newspapers remain mainstream medium, but at the same time, radio emerged, electronic media emerged as well. So from this government report, maybe to the surprise of most of you, actually the news scripts read out by anchors in radio stations and TV stations were supplied by Hong Kong government. So Hong Kong government determined to have a strict control of news content in electronic media. Not only news content, this is a very interesting declassified document from Chinese census sent to the controller of broadcasting as well as the Secretary for Chinese Affairs. This could be referred to if you read the book. So the census said, okay, I went into RTHK, Xianggang Diantai, and inspected their storeroom or library for gramophone records. Okay, 黑胶唱片. Okay, so many of you didn't know what it is. So it's not electronic. So it's a 唱片. So he listened to all the songs in the library. Amazing, right? Amazing work. And he found most of them have no political problem except 8 songs. One of which he specifically mentioned at the last bullet point, saying that one song could be very dangerous, which is called Man Jiang Hong. Okay, so we all know Man Jiang Hong is a Song Dynasty heroic patriotic songs. The census said, although it's not directly against colonial government's interests, but because it's so patriotic, so when it is misused, it might be anti-imperialistic. So therefore, this song was not recommended to be played in RTHK. So you can see that the free speech is not restricted to news content. It could be relating to even small stories or even to the content of entertainment that would be allowed or not allowed to be listened to or to be enjoyed by the people of Hong Kong. So that's my past project. for the next 5 to 10 minutes, I'm going to talk about my next project that I really wish to listen to your views. So I hope I convince you guys that the common law in Hong Kong does not very much embrace free speech. So whether it could still be called rule of law or not, I'll discuss it later. But I'm sure some of the textbooks celebrating freedoms as one of the values inherited from colonial period to today's was factually wrong. Okay. The second value that I'm going to research is about judicial independence. So we all know judicial independence, it has a substantive elements and structural elements. Okay, substantive element relating to trial hearing, judicial impartialities, etc. But structurally, we do not expect an administrator to be a judge, or vice versa, or a past administrator to be a judge, or vice versa, for obvious reasons, because justice not only to be done, but have to be seen to be done. Okay, that's widely accepted. And this is widely accepted colonial legacies in Hong Kong too. But I found, very surprisingly, it's not the traditions of colonial Hong Kong legal system. Look at this judge. This is his CV, okay? Could be very small in print, but I can tell you, he was the Chief Justice of Hong Kong in early 20th centuries. His past experience include serving as Attorney General for other colonies and Attorney Generals in Hong Kong. So as you can see, Attorney General was supposed to be the chief legal advisors for the government, for the executive, and part of the senior management team. And it was not uncommon for chief justices appointed in Hong Kong to have the credentials of serving as Attorney General. This gentleman, he last served in colonial Hong Kong as the colonial secretary. Colonial secretary is, in today's terminology, means chief secretary, which means the right-hand man or woman, okay, mostly man back then, of the chief executive. So obviously, one of the highest members of the senior management team. But as you can see, he also served as magistrates and judges in various colonies. And then in between served as administrators before he was again served as the colonial secretary in earlier 20th century Hong Kong. This very nice looking gentleman, do you know who he is? This is very recent, 1988. His name is called Dennis Roberts. He was the last British Chief Justice in Hong Kong serving until 1988. So his credential was rich. Before he was appointed Chief Justice in 76 in Hong Kong, he was the colonial secretary. So he was the chief administrator in Hong Kong. If the governor was away, he would be the acting governor. And then he was appointed as a chief justice until very recently, 80s, late 80s. So going back, judicial independence, structural judicial independence. Did we have that even in the late 80s, 10 years before Hong Kong was returned to China? What was it in terms of our legal system? Not only, before he was the colonial secretary, he served as the Attorney General for another few years in early 70s. So he was Attorney General, colonial secretary, and then Chief Justice. Not to mention, when he was appointed as a Chief Justice, he did not have any experience as a judge. He was a barrister. He was a senior administrator. He was the chief advisor in legal affairs of Hong Kong to Hong Kong government. That was our legal system. Very funny. So don't tell my dean. Hong Kong Law Journal, 1978, when Dennis Roberts was appointed Chief Justice of Hong Kong, our Hong Kong Law Journal praised and celebrated and say, despite he was part of the government, not ideal, but he was good. Of course, the square bracket was added by me. But you can tell what our colleagues back then was doing. They have their own reason, okay? They have their own reason. It's history, it's history. It was only until the last 2 years of Chief Justice term of Dennis Roberts, he initiated, I suspected, as part of the plan to return Hong Kong back to China, a judicial reform of Hong Kong judiciary, where judiciary was structurally split from the government, okay, in terms of salary, ranks, appointment, and then magistrates. So I'm not sure how many you remember about the principles of judicial independence. We expect judges to be given tenure. Otherwise, if they are seeking renewal of contract every 2 or 3 years, how would you expect them to be independent, especially in the cases against the government? But they were not given tenure for more than 100 years until the few years before Hong Kong was returned. They were given tenure. That was the system now. And after Dennis Roberts, after the judicial reform, this gentleman was appointed as the first Chinese Chief Justice of Hong Kong, okay, Yang Titleung. And he has never done any administrative job. He served as a magistrate, district court, high court, appeal court very nicely. He was made to showcase the principles of judicial independence very late in Hong Kong history. So my question is, I'm sorry for the advertisement, but I'm ending my presentation. But my question for all is, what was it about? So if a system not embracing the core values of common law and rule of laws should not be called a rule of law system, then what should it be called? We are lacking terminology. So should it be called rule of man system? So that means English common law can practice rule of man system, or rule by law system. So that means English common law can embrace rule by man elements, or sub-rule of law, or uncommon common law, or a very popular term today, dual state. Okay, so we still have, we already have dual state back then, or rule of law within authoritarian regime. So beyond the rule of law, rule of man binary, which has been binding us for centuries in terms of thinking about the nuances or characteristics or the labeling of a legal system, what else can we come up with? If we are talking about an English common law system lacking the core values of the rule of law. That's my question for you, and that's ending my presentation. And I'm happy to answer questions and comment. Thank you.